This is Richard Jacobs. I'm here from myduiattorney.org with Ken Stover, a former prosecutor and a criminal attorney out of Reno, Nevada. And Mr. Stover has given us time today to do a video interview. Welcome, Mr. Stover. How are you doing?
I'm doing very well. How are you, Richard?
Good. Without any delay, let's just get into the questions of the interview. The first one's,
Okay.
What made you choose to handle DUI cases, and why do you practice this area of law?
As a prosecutor, it's the #1 committed offense in the United States, so quite clearly I had a lot of DUI prosecution experience. And what I learned in that is that the law enforcement officers don't always understand how to get it done. So on the defense side of things, it seemed an opportunity for me to go in and challenge how they were doing what they were doing, and it's been very successful.
Okay. And how many cases have you handled, and in how many years?
I left prosecution in 2000. I have 15 years experience on both sides of the aisle, but 10 years in defense. You asked me this before, so I took a look at it. The conservative estimate is over 2,000.
Wow, okay.
A lot of cases.
Yeah. So with that in mind, is there any typical DUI defendant circumstance? Do you have more first-time offenders, or are there more men than women, or older people, younger people?
Demographically, because we're Reno, Nevada, we get a lot of visitors to our area. I would say a few more men than women, although I would also say that the women are a little bit more discriminated against because of the manner and methods in which the breath machines work. 60% of them are first-timers who the typical situation is that they had an extra glass of wine for dinner, and they just don't realize how close that .08 limit can be.
Okay. So what percentage of the clients have had, high BACs versus close to being at that limit?
I would probably surprise you to tell you that I prosecuted a .54. And to give you some idea, .30 is toxicologically comatose, although people can get above a .30 if they've had a lot of practice. .40 is toxicologically dead. So I prosecuted a .54, and I defended a young lady who was actually a .62. And you wouldn't be surprised to know that she was in a coma for 3 weeks before she could even be released from the hospital after that event.
Wow.
But those are very rare.
Okay.
If you see things that are triple the legal limit, that happens. I would say 20% of my cases are above the .18 level.
Huh. Okay. And what percentage of them have gone to trial versus been able to be settled out of court beforehand?
You always want to try your case first in front of the prosecutor. If you're in front of the judge, the prosecutor didn't agree with you. It's better to get the prosecutor to agree with you. In Nevada, the law says that the prosecutor believes they can prove the case, they have to go forward to trial. So you get the prosecutor to believe they can't prove their case, and you get a negotiation to what we typically call a wet careless or a wet reckless. At times, we can sometimes even get a dismissal, but a careless or a reckless is certainly what we consider a success when you're being charged with a DUI and the implications of being convicted of that.
Yeah, definitely. What would you say is unique about the DUI laws in Reno and in your particular county?
Actually, I would say in our particular state, comparatively, I understand that other states have the right to have a jury trial for a misdemeanor DUI. Here in Nevada, that wouldn't be true. They afford you only a jury trial when you're faced with a felony. Misdemeanor DUIs are first and second offense DUIs. We also have drug driving laws that are a little bit different than in other states. So, for example, we have zero tolerance when it comes to marijuana and driving. And so those are some very challenging cases at times because people that weren't at all impaired somehow have levels that are higher than the per se limits. 2 nanograms in your blood for tetrahydrocannabinol, 5 nanograms for the metabolite. Now, 5 nanograms is such a low amount that somebody may have smoked a weekend before and still have that limit in their system. So those can be challenging cases because the officer probably didn't develop any probable cause to believe that the person was impaired, yet somehow got to the blood. So there's going to be a lot of serious questions there. And then the irony of that is that we also have heroin limits, LSD limits, and PCP limits that are so abysmally high that they would actually kill a human being if you took those levels.
Really?
So yeah, I think that the irony is that in our state, where we allow gambling and prostitution and drinking 24 hours a day, 7 days a week, we don't allow anyone to consume marijuana and drive on our highways, But yet we're willing to say that you can consume heroin, PCP, and LSD and drive on our highways all you want.
Huh.
Laws are what I would say, as Shakespeare once said, the law is an ass.
Okay. That's unique to your area. It's interesting. Huh.
Nevada has some very ridiculous laws.
Interesting.
Very ridiculous.
Okay. What would be your best tip? Someone's been driving, they've just been pulled over, the police are approaching them. What, at this point, should they do and shouldn't they do?
No, well, I have a joke.
Okay.
If you've seen the police officer pull behind you, you immediately grab the emergency Jack Daniels bottle. You step outside of the car, certain to have your keys with you. You throw the keys into the desert, you open up your emergency Jack Daniels bottle, you drink that. As you look at the officer, you say cheers. You then put the bottle down, and you put out your hands to be arrested. You've just consumed alcohol after driving, and I don't think they can convict you. Please don't follow this advice.
Okay.
I would think that the best thing that people could do is it's easy. Leave your keys at home. But if you're in a position that you made the mistake, for whatever reason, that the police are behind you, you cooperate. Don't leave a bar after drinking a shot of anything and not consider putting Dentine in your mouth or Visine in your eyes. People are going to be stumbling, bumbling, fumbling, impaired, and they're never going to mask it with Visine and Dentine. But if you're a .06 and you just want to get home and not get through the test, don't give them the smell of odor of alcohol in your breath.
Okay.
It's practical advice, but it's better than legal advice.
Okay. So in your practice, what kinds of help can you give to DUI defendants? I think you mentioned possibly getting their DUI knocked down to a wet reckless, but what other kinds of things can you do?
Well, first thing you want to do is win the case, but you don't win every case. So you have to have a second goal or you're not doing anything, and that is to minimize damages. With the ways that the laws are applied and the things that the police officers, can say about you and do to you, the levels that they say were in your system can affect how the judge will treat you. And so you want to minimize those damages and make sure that you're not reappearing in their alternative program courts and doing things that, if you're set up to understand the loss, you can minimize your damages. And then you don't go back to jail, you don't go see the judge every week, you don't get a scram unit on your ankle, all the things that the judges like to do to you around here. You want to minimize damages. And then on the other side of it, if you're dealing with somebody that it really is at a .30 or a .40, 54, 63, you have to address that alcoholism issue, and you have to counsel that, because that's a no-win situation for anyone. And those type of levels mean that there is a problem. And so you help them with that as well.
I have an unusual question. Is there any difference? You talked about judges, how they treat people. Would a judge treat someone differently if they were a .09 versus a .15, or it really has to be a lot higher, .2, .3? Where have you noticed that they just kind of look down on you?
That's in our state, we have a .18 level. The legislature has said if you're over a .18, and that's why I use that number when I said 20% of my cases are over .18,
okay,
then you have to be evaluated to determine what kind of alcohol problem you may have, and then the judge will take specific measures to have you address it. So if you're a .17, they're going to treat you differently than a .09. But if you're a .15, .09, no, probably not too differently if you utilize my office. I don't think so.
Okay.
I don't think there'd be a problem at all.
Okay. It may be hard to say, but what percentage success have you had in, getting charges reduced or minimizing damages? How often can you do at least something?
If I reduce the charges from DUI to wet careless, wet reckless, roughly about 50% of the time.
Wow.
You stand a 50-50 shot if you call me.
Huh. Okay.